The heights by great men reached and kept were not attained by sudden flight, but they, while their friends slept, were toiling upward in the night. Welcome back, my UPSC gladiators. 4 days down, 24 to conquer in our target prelims 2024. You have already slain a chunk of prelims. Today, let's crank it up a bit, break barriers, and own our goals. So keep the momentum crushing, finish strong, and show those prelims who's the boss. This is session 5 of Target Prelims 2024, Indian Polity. I hope you are aware of the schedule. This is our schedule. Tomorrow we'll have the session on geography, in fact for the next 2 days, then ancient history, etc. You can see the schedule and plan your revision accordingly. Okay, let's begin. First question. Consider the following statements regarding the reorganization of states and UTs in India. Bills seeking to amend the names of states or UTs can only be introduced in the Rajya Sabha. So when it comes to reorganization of states, the article we are dealing with is Article 3. So such bills can be introduced only in the Rajya Sabha. There is no such criteria. Such bills can be introduced in either house. One is wrong. Such bills require the prior recommendation of the president before introduction. This is correct. This is one criteria to bring such bills. Number 3, the bills must also be sent to the concerned UT, the Union Territory, for its opinion in case it involves modifying its name. This statement would have been correct if it was the state. So whenever any state's boundary has to be changed or its name has to be modified, you need to send the bill to the state legislature for its opinion, which is not binding, but the same is not needed for the Union Territory. So 3 is wrong. Number 4, such bills require a special majority in the parliament for the passage. Special majority is not needed. We know very well Article 3 provides for reorganization by the parliament by law. By law would mean what? By a simple majority. So this is also wrong. How many of the above statements is or are correct? So only one is correct. A is the right answer. Next question. Consider the following statements about the Citizenship Act of 1955. The provision relating to loss of citizenship via deprivation is limited to those who have obtained citizenship through registration or naturalization only. Now see, under the Citizenship Act of 1955, there is one section 10 which talks about how the government of India can take away your citizenship. See, of course, we can give up our citizenship voluntarily or we can take some other country's citizenship. So in those two situations, of course, our Indian citizenship is gone. But there is one way in which the government can also take away our citizenship. That is section 10. And this statement is correct because the government can only take the citizenship away of those categories of people who have obtained it either through registration or through naturalization only, not ones who have obtained it via being born in India or through descent. So one is absolutely correct. Number 2, once India acquires a foreign territory, all the people residing in the area become Indian citizens automatically. So see, once India acquires, let's say tomorrow, though we don't need to and there is no interest of ours, but let's say we tomorrow capture Pakistan. So once we capture Pakistan, all the people living in Pakistan, will they become Indian citizens? They can, but not automatically. Why? Because if India acquires any foreign territory, the central government has to issue a separate notification ensuring or providing for citizenship for those people of the area. Otherwise, they'll be stateless people. So it does not happen automatically. You need a separate notification for this. This is nothing but section 7 of the same Citizenship Act of 1955. Section is not important, the information is important. So, of course, 2 becomes wrong. Which of the statements is correct? Right answer A1 only. Next question. Consider the following statements regarding the CAA 2019, the very controversial act passed in 2019. It requires the states to prepare a National Register of Citizens, NRC, for their respective state. Does it require the state to prepare an NRC? Yes. As far as the NRC is concerned, it can be prepared, but not under CAA 2019. This is nothing new. Yes, the controversy might be new, but the NRC provisions are very old. Back in 2003, we made some rules called the Citizenship Rules of 2003. And as per those rules, rule number 3 to be exact, this statement would have been correct, but not as per CAA 2019. So yes, the controversy is new, but the preparation of NRC has been provided for since 2003. So 1 is wrong. Number 2, it exempts Schedule 5 and 6 areas from its provisions. Yes, CAA, the benefits of CAA will not apply to all those illegal migrants living in the Schedule 6 areas. The 10 autonomous districts in 4 northeastern states of Assam, then Meghalaya, then Mizoram and Tripura. However, it is still applicable to or for those or on those people who are residing in Schedule 5 areas. So 2 is wrong. Schedule 5 areas are primarily districts or even smaller areas, scheduled areas in 10 states across the country. Those 10 states are Andhra Pradesh, Chhattisgarh, Gujarat, Himachal, Jharkhand, MP, Maharashtra, Odisha, Rajasthan and Telangana. Anyway, so both statements are wrong. What's the right answer? The right answer is the statements which are incorrect. Right answer is C. One more thing, apart from Schedule 6 areas, the CAA, the benefits of it are also not applicable to those illegal migrants who are living in those areas which are declared to be inner line permit areas. Inner line permit areas like in the states of Arunachal, in the states of Mizoram, Meghalaya, etc. Mizoram and Nagaland, etc. Okay. So yes, this is the case with respect to CAA 2019. Next question. As per Part 1 of the Indian Constitution, which statement correctly describes the territorial division of India? Article 1 declares India as a sovereign, socialist, secular, democratic republic, setting the stage for the rest of the Constitution. This is mentioned in the preamble. I think because of the recent controversy that erupted with respect to Article 1, everybody now knows that Article 1 is what India, that is Bharat, shall be a union of states. So 1 is wrong. B. The term Union of States was chosen to denote that the Indian Federation is the result of the states' indestructibility, unlike the American Federation, which is based on the destructibility of the states. It's the exact opposite. India is an indestructible union of destructible states, whereas USA is an indestructible union of indestructible states. Meaning what? In India, the state's boundaries can be destroyed by the center without the state's approval also. Article 3. This, however, is not possible in USA, because in USA to modify states' boundaries, states' approval is mandatory. Okay, so this is the case. This is wrong. Number 3 or C. India is a federation of states and UTs with the power to alter state boundaries resting solely with the state governments. We all know this power resides solely with the parliament, not the state government. This is also wrong. So D has to be correct. D is the right answer. India consists of states and UTs, and the parliament has the power to admit new states, form new states, alter boundaries, and change the names of existing states or union territories. Article 2 and 3 talk about this itself. So D is the right answer. Admitting new states, etc. Also, Article 3, any kind of domestic reorganization is all under the control of Parliament. Next question, which of the statements regarding the UTs is not correct? Every UT is administered by the president acting through an administrator. That's true. That's true. Article 239 talks about all these provisions with respect to the union territories in general. The parliament can specify the designation of an administrator of a UT. So you know very well that in the UTs, the head is called the administrator. But sometimes for some UTs, they are also called a lieutenant governor, LG, like in the case of 5 UTs. In the comment section, please write the names of all those 5 UTs where the administrator is called LG. Okay, so let's see. But this statement is actually wrong because the parliament will not specify, the president specifies it. So B is wrong. We wanted the not correct statement. B is the right answer. C, the president may appoint the governor of a state as the administrator of an adjoining UT is correct. Article 239 clause 2. Also, please remember this provision. It's important because it's the discretion of the governor. So whenever the governor of any state is given the power to manage an adjoining UT, the management of that UT as the administrator is the discretion of the governor. Otherwise, for a state, governor is bound by the advice of council of ministers. That's the practice, but not for that particular UT. The only condition would be the UT should not have an assembly. Okay, so C is correct. D has to be correct. The administration of UTs can be changed by a law made by parliament. Yes, of course. B is the right answer. Don't forget to write the names of all those 5 UTs where the administrator is called the LG. Next question, with respect to the legislature of the National Capital Territory of Delhi, NCT of Delhi, the UT of Delhi is actually called the NCT of Delhi. Consider the following statements. The Chief Minister and the other Council of Ministers are appointed by the LG. So in every state, including your state, if you belong to a state, you know very well that the CM is appointed by the governor. Similarly, in Delhi, the CM must be appointed by the LG. That's not the case, okay? In Delhi, the CM and other ministers are appointed by the President of India, okay? Please remember this very important point. It is not the LG but the President. This is Article 239 AA Clause 5, okay? Number 2, the strength of the Council of Ministers is fixed at 15%. Again, we know very well, right? Back in back through the 91st Amendment Act of the year 2003, modifications were made to Article 75, Article 164, and what was the modification? The modification was that the maximum number of ministers, including the PM or the CM in the Council of Ministers, should not exceed more than 15% of the total strength of the lower house, whichever is it is Lok Sabha or the State Assembly. That means in Delhi also it must be true. Sadly, that's not the case. In Delhi, this limit of ministers should not be more than 10%, not 15%. Please remember this as well. This also is a constitutional provision. Same article, different clause. Clause, not really important. Article, not really important. The content is important. So this is also wrong. Which of the statements is or are incorrect? So C, both 1 and 2 are incorrect. Next question, with respect to the legislature of NCT of Delhi, consider the following statements. Most of the members of the assembly are directly elected by the people, while some are nominated by the central government. You know, this provision is actually true for the UT of Pondicherry. In the UT of Pondicherry, which has a 33-seat assembly, 30 are elected, 3 are nominated by the center. But that's not the case for Delhi. It's wrong. Delhi, all 70 seats elected. The assembly can make laws on all the matters of the state list and the concurrent list. We know very well this is also wrong. Why? Because there are 3 topics of the state list: entry 1, entry 2, entry 18. That is public order, police, and entry 18 is land. On these 3 topics, the assembly cannot make laws. 2 is also wrong. Which of the statements is or are correct? D, neither 1 nor 2. Next question. With reference to the J&K Reorganization Act of 2019, consider the following statements. According to the Act, both the UTs of J&K and Ladakh are provided with a state legislature. See, the UT of J&K does have a legislature. We fully agree on that. Sadly, the UT of Ladakh does not have a legislature. This means 1 is wrong. Number 2, the UT of J&K will have an advocate general to provide legal advice to the government of the UT. Of course, just like states have an advocate general, center has an attorney general. Similarly, the UT of J&K will have an advocate general. So 2 is correct. Which of the statements is or are correct? Right answer B, 2 only. Next question. In which of the following matters a constitutional amendment is possible only with the ratification of the legislature of not less than half of the states? Meaning, we are looking into Article 368 number 1, but we know very well that Article 368 talks about amending the constitution, any provision of it, with a special majority. However, there are certain provisions, if you want to modify those provisions, which are supposedly the federal features, part of what we would call of the federal structure of our country. If you want to modify those provisions, then you have to send the bill to the concerned states as well. And the moment half of the states, at least half of the states approve with a simple majority, the modification has been made. And there is no time frame set within which the states have to approve it. So what all provisions are there? Union list, yes. If you want to modify any list, states approval is required. If you want to change the procedure of Article 368, yes, states approval is required. Administration of the 5th schedule areas, no. This is done by a simple majority, by law. No need for Article 368. Jurisdiction of high courts for UTs, yes. So the provisions for high courts and Supreme Court requires what? The ratification, the approval by the states also. Ratification means approval. And the 5th one, reorganization of states. This is also wrong. Article 3 is done or achieved by law, a simple majority. So 1, 2 and 4, B is the right answer. Okay. So please make sure you remember these points. This is important. Which all provisions require the state's consent as well? Okay. Next question from Election Commission. Which of the following statements with respect to Election Commission of India is incorrect? Incorrect. Okay, let's see. The removal of CEC is same as that of Supreme Court judge. Of course, we know it. Article 324, Clause 5. We have seen this provision a couple of days earlier as well, while we were discussing about the removal of certain constitutional and statutory dignitaries. B. The oath of CEC is mentioned in Schedule 3 of the Constitution. No, not at all. The oath of CEC is not mentioned there. The oath of ministers, the oath of candidates, the oath of also legislators, the oath of Supreme Court and High Court judges, and the oath of CAG is mentioned. Nobody else. So B is wrong, hence is the right answer. Let's read C as well. The CEC and other ECs receive the same salary as a Supreme Court judge. Correct. And the ECI decides on matters of splits and mergers of parties is also correct. Okay. Next question. Consider the following statements regarding ECI, Election Commission of India. The removal of members of ECI is the same as that of a Supreme Court judge. Is that correct? CEC, yes, of course. The CEC's removal is same as that of Supreme Court judge. What about other election commissioners? Not at all. Other election commissioners will be removed on the recommendation of the CEC. The procedure, the ground, nothing is mentioned. So one is wrong. Number 2, as per the constitution, the election commissioners have a fixed tenure of 6 years or until they reach the age of 65 years, whichever is earlier. See, this fact is correct. I fully agree that this fact is correct. My point is it mentioned in the constitution? No. It is a mere statutory provision. Statutory provision. Why? Because it was mentioned in one old law and also the new law which was passed to supposedly bypass the Anu Barnwal case. The law is called the CEC and other ECs Appointment, Conditions of Service and Term of Office Act of 2023. As per that law, this fact is correct. So not as per the constitution. So which of the statements is or are correct? We know very well. D, none. Next question. Consider the following statements: remission, commutation and pardon. Okay, the definition of these. Remission. It affects both the punishment prescribed for the offense and the guilt of the offender and may completely erase the guilt. Oh, this definition I think is meant for pardon, not for remission, because remission means reducing the period of punishment. So one is wrong. Commutation means changing the character. So what is commutation here? Temporary suspension of the punishment. This is called reprieve. When you have a temporary suspension of the punishment awarded by a court of law, we call it reprieve. This is also wrong. Pardon. Changing the punishment from one category to another. Oh, this is changing the nature of punishment. This is what is called commutation. Okay. So the third one is commutation. This is also wrong. All three are wrong. So how many pairs are correctly matched? None of the pairs are correctly matched. Next question, with regard to the RPA 1950, consider the following statements. The Act defines corrupt practices which results in disqualification from voting in the elections. Corrupt practices, are they defined anywhere? Yes, they are. Section 123. But the statement is still wrong because it is not defined in RPA 1950. It is defined in RPA 1951. Okay. And number 2, according to the Act, the electoral roll for each constituency shall be divided into parts corresponding with the polling area determined by the Election Commission of India, ECI. Yes, the polling booth. This is nothing but the polling booth. Right? This means that the polling booths are created by the ECI. 2 is correct. So which of the above statements is or are correct? B2 only is the right answer. Next question. Consider the following statements in context with the RPA 1951. The Act lays down the actual conduct of elections in India, including the administrative machinery for conducting elections, the poll process and the counting of votes. See, 1951 Act is the major one, and yes, absolutely correct. That act actually includes all these provisions and the actual conduct of elections. Number 2, Section 8 of the Act specifies the duration of disqualification from contesting elections for persons removed from the government office due to disloyalty. So, in future, if some of you are removed from office on the grounds of corruption or disloyalty, you will not be allowed to contest elections for 5 years. But that is mentioned under Section 8 of the what? RPA, or not is the question. It is not, because this is mentioned under Section 9 of the RPA. Section 8, if you remember, comprises of those 3 clauses where based on the nature of crime or the law, you will be disqualified for either 6 years plus jail, or you'll be disqualified for 6 years plus jail when the minimum jail is 2 years, or you can be disqualified for 6 years plus jail if the minimum jail term is 6 months, depending on which law you have broken or under which law you are convicted. I think you all are aware of Section 8, 8A, 9, 9A, and of course 10 and 10A. If not, please remember all these sections, including Section 11, which gives Election Commission the special power to either remove or reduce the period of disqualification, but with reasons to be recorded. This is important. So 2 is wrong, 1 is right. Which of the statements is or are incorrect? Right answer is B, 2 only. Next question. Which of the following states does not have a tribal advisory council? You know, all these areas called Schedule 5 areas. These Schedule 5 areas are across 10 states. And in every state which has a Schedule 5 area, you have to form a TAC called Tribal Advisory Council. But there are certain states which do not have Schedule 5 areas, but still the mandate is that because they have a substantial tribal population, they need to have a TAC. Which are those 3 states? These 3 states. In these 3 states which are not under Schedule 5, the state has to form a TAC. So Andhra, yes, has a TAC. Tamil Nadu, through this, has a TAC. Rajasthan, of course, comes under scheduled areas, has a TAC. Karnataka does not have a TAC. D is the right answer. Okay. Next question. Consider the following statements with respect to Schedule 6 areas, not 5, 6 areas. 6 areas, ADCs, Autonomous District Councils. First one. Laws made by the Parliament can be modified in their application to Mizoram by the governor. This is wrong. Laws made by Parliament can be modified in their application to Mizoram by the President. Number 2. Laws made by the state legislature of Assam can be modified in their application to the state by the President. This is wrong. State made laws are to be modified, or central made laws are to be modified in Assam by the governor only. Number 3. Governors of these states have no powers whatsoever to cancel or suspend laws made by the ADCs under any circumstance without consulting them. This is wrong. If the ADCs make rules and regulations which threaten the security of the country or are prejudicial to public order, then the governor can cancel or annul those laws. Okay, so all 3 are wrong. Just to clarify, in case of Assam, modification in laws, whether made by center or the state, is done by governors only. In the case of Meghalaya, modification in laws in their application, whether made by center or states, is done by the Parliament only. Sorry, the President only. Not the Parliament, the President only. And when it comes to the other 2 states, that is the states of Tripura and Mizoram, for these two states, it depends. If it's a central law, then it's the president who will modify the laws. If it's a state law, then it's the governor who does it. So please make sure you remember this differentiation. It's important. There can be a prelims based question from this very topic. So how many statements given above are incorrect? Once again, all three are incorrect. C is the right answer. And next question. The Indian Constitution provides for the establishment of a TAC in certain states. Yes, of course. Which states? The four states that we saw the names of: Assam, Meghalaya, Mizoram and Tripura. Which of the following statements is or are correct in this regard? Correct statement. A tribal member of the Legislative Assembly of the concerned state can be a part of the council. So the Indian Constitution provides for the establishment of TAC. Oh my bad, I just said those four states. TAC is meant for Schedule 5 areas. Apologies guys, slip of tongue, right? So these are 10 states. Not those 4 states. Those are the ADCs. So TAC, Schedule 5, 10 states. Number 1, a tribal member of the Legislative Assembly of the concerned state can be a part of the council. Yes, of course. In TACs, the tribal advisory councils, which comprise of 20 members, 3/4 of them, 3/4 members are scheduled tribe MLAs. I hope you are aware that we have reservation for scheduled caste and scheduled tribes in the Lok Sabha and the Vidhan Sabha, right? So all those scheduled tribe MLAs, they are a part of the TAC. Not all, it depends on the seats as well. So 3/4 members of TAC are scheduled tribe MLAs in the state. Yes, one is correct. The council provides advice to the governor on matters relating to the welfare and the advancement of scheduled tribes. Yes, of course, absolutely correct. Number 3, the rules related to the council can be prescribed and regulated by the governor is also correct. All 3 statements are correct. Right answer is correct. All 3. Okay. So please, it is Schedule 5, not Schedule 6. Just to remember, Schedule 5 is TAC. Schedule 6 is ADC. Okay, next question. Consider the following statements regarding the nota option. None of the above option in elections. So we have nota option, right? The cross symbol in the button is the nota. When you reject all the candidates, the arrogance of the voter that everybody is useless, that's nota. The votes cast for nota are included in the total valid votes for the purpose of calculating the return of security deposits to candidates. See, when it comes to elections, under RPA 1951, if you are contesting elections for the post of MP, you have to give some security deposit, 25,000. Figure not really important. And if you are contesting for a reserved seat, then this amount is halved, 12.5 thousand. Similarly, if you are contesting for the post of MLA or MLC, then the amount is 10,000, but for an SC/ST seat, the amount is halved to 5,000. Now, this is like a security deposit to, contest elections. Just like in your school and college days, security deposit, because in case on the last day you break some things, science lab equipment, you break the fan, etc., benches, then they might deduct some money from your security deposit. Okay, like in your PGs. Same thing. So here what happens is, if you lose and you fail to get some votes, that is 1/6 of the total votes polled. Total votes polled by all the candidates. Only the candidates, not the nota. Nota votes are not included. This is wrong. They are not included. Always remember. Okay. So if you fail to get 1/6 votes, then your security deposit is forfeited. Zamanat zabt is a very popular term. Lot of parties are experts in all these things, especially in the last 10 years. We have seen the rise of single party dominance, at least at central level. So a lot of parties have to go through this. Their candidates have their security deposit forfeited because of extremely poor performance, right? Anyway, number 2, even if nota receives more votes than any individual candidate, the candidate with the highest number of votes among the contestants must still be declared the winner. Is that the case? Let's take an example. Let's say there is a constituency A where there are some candidates X, Y, Z, and we also have the nota option. Now, assuming there are 100 electors or 100 voters, if let's say X gets 25 votes, Y gets 15 votes, Z gets 10 votes, that would mean how much? 50, and nota gets 50 votes. In this case also, who has received the highest votes? Nota. What to do now? Does not matter. Remove the votes of nota. Amongst the candidates who has received the highest number of votes is declared the winner. Are we clear? So yes, even if nota receives more votes, the candidate is declared the winner. Right? How nice a system. What's the point of nota then? Please write in the comment section, what do you think on this point? Do you think that nota would make a difference in this situation? And if yes or no, please give some suggestion that if at all you want to modify this, what would your suggestion be? Okay. Moving on to the next question. Which one of the following statements best describes Gram Sabha? Gram Sabha. Gram Sabha is defined under the Constitution, Article 243, Clause B. What is Gram Sabha? Gram Sabha primarily is the village assembly consisting of all the registered voters, meaning all those people whose names are in the voter list, adult population of the village who are in the voter list. That is called Gram Sabha. The entire village population, but adults, and plus names in the voter list. So it's a local governor. Gram Sabha is not a governing body, firstly. It's an elected, no, Gram Sabha is not an elected body also. It's a village assembly consisting of all the registered voters in the area of a panchayat. Seems to be correct. C is the right answer. Very good. It's a village assembly of all the people, not all the people, all the voters. All the people would also include kids under 18. They are not voters. Okay. So C is the answer. Next question. Which of the following is or are not compulsory provisions? So very interesting is this fact that under your provisions of panchayats and municipalities, there are certain mandatory provisions, right? Compulsory provisions and certain optional provisions. Wherever you find this phrase, state legislature may by law decide, right? Or state legislature by law must decide. That's a provision left for the states, and if you have the word may, then it's completely optional. Okay. So, not compulsory provisions. Organization of Gram Sabha in a village. No, that's a mandatory provision. Okay. Article 243, capital A, mandatory provision. It has to be done. Gram Sabha is mandatory. Constitution of an SFC, State Finance Commission. This is a mandatory provision. Article 243, capital I. Mandatory provision, not an optional provision. Compulsory provision. Number 3, giving representation to members of parliament in the panchayat. So MPs can actually become members of either the district panchayat called the Zilla Parishad, or can also be members of intermediate level of panchayat, block panchayat, taluk panchayat, etc. Whatever name you may call it. However, it is an optional provision. Why? State legislature may by law provide for. May. This is an not a compulsory provision, an optional provision. Hence 3 is the right answer. So B, 3 only is the right answer. Next question. On premature dissolution of a panchayat, which of the following statements about the newly elected panchayat is or are definitely incorrect? Very strange. The question is worded in a very unique fashion. Definitely incorrect. 100% incorrect. Right? Definitely. Like some parties or most parties' chances of winning in this election in Lok Sabha. Definitely not possible. Anyway, so coming to the statements. First one. Before that, I hope you're aware that the duration of Panchayat is 5 years, just like the Lok Sabha or the Vidhan Sabha. Article 243, Clause E, talks about duration of the Panchayats. Okay, now, it will be, let's assume that before the end of 5-year tenure, the Panchayat gets dissolved prematurely, whatever reasons, that the state government will decide. It will be reconstituted to serve a full term of 5 years. No, that's not the case. It is a case for Lok Sabha and Vidhan Sabha, but not for Panchayats. This is never going to happen. No fresh elections shall take place for the remainder of the term. Is that correct? I mean, if the Panchayat gets dissolved, will we not have elections there? Yes and no. Yes, of course, but if the remainder tenure is less than 6 months, then there is no need to conduct elections. We'll wait for 6 months. After 6 months, when we are conducting elections for all the panchayats, then for that panchayat also it will be conducted. Okay, so it is actually possible. It depends on whether the remainder tenure is less than 6 months or not. Possible. Number 3, it will be reconstituted, again elected to serve the remainder term, and that's also possible. It depends. If the remaining period is more than 6 months, then we'll have to reconstitute the panchayat again. So 2 and 3 are possible. So we cannot say they are definitely incorrect. Fourth one, state legislative assembly shall decide the course of. No. It is mentioned in the constitution that either this will happen or this will happen. So the assembly has no choice to decide. Neither are we going to reconstitute a panchayat for full 5 years. Why? Because see, there are 2.7 lakh gram panchayats in the country. If every gram panchayat has a different cycle of elections, we'll go crazy. Currently, just 28 states and one central election. Of course, apart from the 2 UTs of Delhi and Pondicherry. And in that case also, we have so many elections clubbed together and we are going crazy that every few months we have elections somewhere, simultaneous elections, one nation, one election, all that is happening. Imagine for 2.7 lakh panchayats, if the respective states in their states with thousands of panchayats, you have different elections every day. Then the SEC will go crazy and also wastage of resources. So we have to make sure that these elections are in sync. That's the reason. Okay. So 1 and 4 are definitely incorrect. B is the right answer. Okay. Next question. Where a proclamation of emergency is in operation, the right to move to any court for the enforcement of fundamental rights, except of course 20 and 21, could be suspended. How can you suspend the enforcement of rights? This can be suspended by an order by the president. So automatically, no, this will not happen automatically. Only by an order made by the president, yes, it requires a presidential order. Only by a law made by parliament is also wrong, and only by an order made by a constitutional bench of Supreme Court, complete nonsense. This is Article 359. Okay. By the way, originally, your right to move to the court to protect any of your fundamental rights could be suspended, including Article 20 and 21. This exception was added through a constitutional amendment act. Please write in the comment section which amendment act added the exception of these 2 articles. Now thankfully these 2 articles will, or the right to move to court to protect these 2 articles will not be suspended, and that particular modification was done to bypass a very famous or rather infamous judgment. Okay, I'll tell you which modification was it. It was the 44th Amendment Act of 1978. You please write in the comment section what was that amazing judgment of Supreme Court, where Supreme Court said that your right to life can also be taken away if the government wants to. Right? So, I mean, a black letter day in the history of Supreme Court. That was a judgment. A judgment of 1976. I want you to write the name of the very infamous judgment. Okay, a 5-judge constitutional bench was there. Next question. Consider the following statements about the panchayats in India. The provision for establishing Panchayati Raj is explicitly mentioned in the original constitution. This is wrong. We know very well that the provision for establishing panchayats is not mentioned originally. Yes, we have an Article 40 which says that the state shall endeavor to form panchayats, but the creation is not mentioned. So this is wrong. When was it added? 73rd Amendment Act of the year 1992. Number 2. The 73rd Amendment Act 1992 provides for a 3-tier system of panchayat for all the states having population of over 2 million. 2 million means what? 20 lakh people. 1 million is 1 lakh. Yes, that's correct. Because there's an exception. If any state has a population of less than 2 million, that is less than 20 lakhs, that state may not, if it wants to, may not constitute intermediate level of panchayat. That's possible. So you may skip that. Okay. A very good example is a state like Sikkim, which has a population of around 6 lakhs. I mean, as per 2011 census. So yes, no intermediate level in Sikkim. So a 2 is correct. Number 3. The states can empower the panchayat to levy, collect and appropriate taxes, duties, tolls and fees. Yes, can, may, allowed. This is Article 243 capital H. And number 4, states are mandated to constitute a finance commission to review the financial position of the panchayats. Yes, of course. SFC every 5 years must be constituted by the governor of the state. 2, 3 and 4 are correct. How many statements are correct? C. Only 3 statements are correct. Next question. A proclamation of emergency, that is national emergency, is if approved by both the House of the Parliament, continues for 6 months and can be extended for an indefinite period. B. Continues for 6 months and can be extended for up to 3 years. C. Continues for 6 months and cannot be extended, continues indefinitely till it is revoked. A is the answer. Once national emergency is imposed, it continues for 6 months and it can be extended by 6 months at a time for an indefinite period. This 3 years upper limit is meant for president's rule, and continues indefinitely is the case of financial emergency. Okay. A is the answer. Next question. The 73rd Amendment Act of 1992 has fulfilled the objective under Article 44 to provide for local self-governance in rural areas. This is wrong. Article 44 is for UCC. This is Article 40. The content was right. The article was wrong. 1 is incorrect. Number 2. Panchayati Raj institutions are exclusively rural. Yes or no? Yes, of course. With no equivalent governance structure for urban areas. We do have it. For the urban areas, don't we have the concept of municipalities? Under Part 9A. That's there. So this is wrong. Both statements are wrong. Which other statements is or are not correct or incorrect? C is the right answer. Next question. Which of the following comes under the powers and jurisdiction of the ECI, the Election Commission of India? Cancel polls for irregularities. Yes, of course. ECI can cancel polls for irregularities, any kind of malpractice that might happen. Election symbol disputes. Yes, of course, it's a power of the ECI. Political party splits and mergers. Yes, of course, power of ECI. Deregister political parties. See, registration of political parties is done by the ECI, section 29 capital A of RPA. Registration of political parties comes under the control of what? Election Commission of India. The question is, who will deregister these parties if required? So it is not the ECI but the central government. But yes, on the recommendation of ECI, but this is actually done by the Government of India, but on ECI's recommendation, which is not binding, but still. This is the case. So 4 is not correct. Number 5, publish the notification for elections. This is also wrong. Election Commission announces the election schedule. The notification for the election schedule is published by the President or the Governor. Okay. So this is the case. So the right answer would be 1, 2 and 3. B is the right answer. Next question. With reference to the financial emergency in India, consider the following statements. Financial emergency, Article 360. There is only one article for financial emergency. Article is very important. Please make sure you remember it. There is no maximum period prescribed for its operation in the Constitution. Absolutely correct. In fact, there is no maximum period for national emergency also. There is a maximum period for President's rule. What is that? 3 years. In case you want to extend it, you will have to use Article 368. Modification in the Constitution is required. Number 2, repeated parliamentary approval is not required for its continuation. Yes, of course, that is absolutely correct. Why? Because once financial emergency is approved by the parliament by a simple majority within 2 months, it can continue forever till the government, the president revokes it. But for the national emergency, for president's rule, even after you get it approved by the parliament, you have to keep on getting it approved every 6 months. Okay, that's the case. So both statements are correct. Which statement is correct? Right answer is C, both 1 and 2. With reference to the DPC, District Planning Committee, this is a constitutional body, DPC. The article for DPC is Article 243 ZD. We have a similar body called MPC, Article 243 ZE. MPC. The 74th Amendment Act provides for the establishment of DPC. Yes, that's correct. Not the 73rd, mind you. These planning committees are formed under 74th Amendment Act. 1 is correct. 4/5 members of DPC are nominated by the governor. No. 4/5 members are elected. Okay, not nominated but elected. And elected by and from amongst the elected members of panchayats at the district level and all the members of municipalities. So 4/5 members are elected, rest are nominated. 2 is wrong. It has representation from both rural and urban population. Yes, of course, because it has elected members from the panchayats at the district level as well as municipalities. So the rural representation, the urban representation. 3 is correct, 1 is correct. How many statements are incorrect? A. Only 1. Next question. In which of the following situations would the imposition of President's rule under Article 356 be improper? Maladministration in a state. Allegations of corruption against the chief minister if the state government works against secularism. Or number 4, disregard of a constitutional direction of center by a state. See, the misuse of Article 356, we have a very interesting judgment, S.R. Bommai judgment of 1994, and there are also some guidelines from Sarkaria Commission in this regard. So S.R. Bommai judgment said that there are only 3 reasons why President's rule can be imposed in a state. Number 1, hung legislature. When no party is able to form the government and the governor has exploited, governor has tried every possibility, exhausted every possibility of anybody being able to form the government, has given chance to every major party, and even then nobody could form the government, then of course, do it. Number 2, if the state government works against secularism. And number 3, of course, under Article 365. And what is 365? If the center gives a direction to the state and on a topic which is a central topic and the state does not follow it, then the center can come to a conclusion that the government in the state is not being carried on in accordance with the provisions of the constitution, which could amount to precedent's rule. So yes, in these two cases, yes. Otherwise, all other reasons will be wrong, improper reasons to impose what? Precedent's rule. Improper. 1 and 2 are improper reasons. Right answer is A. 1 and 2 only. With reference to the effects of financial emergency, consider the following statements. There is no requirement to get the proclamation of financial emergency approved by the Parliament. No. Once the financial emergency is proclaimed, within 2 months, you have to get it approved by the Parliament by a simple majority. This is required. Now, once it is done, then you don't need the recurring approval every 6 months. The same approval is needed for President's rule also. Within 2 months, with a simple majority, and for a national emergency within 1 month with a special majority. So this is the case. So 1 is actually wrong. Number 2, the president may give directions for the reduction of salaries and allowances of judges of the Supreme Court and High Courts. Yes, any class of persons' salaries can be reduced during a financial emergency. Of course, the country has no money. What are you crying about? Give my salary, give my salary. Forget all that. No money, right? So, which of the statements given above is or are correct? B. 2 only. Next question. Consider the following statements regarding the inherent rationale of local self-governance in India. Local self-governance is intended to promote participatory democracy by empowering citizens to have a direct role in decision-making processes that affect their daily lives and community well-being. This is correct, of course, right? Participatory democracy, democratic decentralization, people's participation, the two principal ideas based on which we have the concept of panchayats in our country. Okay, the establishment of local self-governance institutions is solely for administrative convenience and has no bearing on enhancing democratic values. No, of course, it does. The whole point of local self-governance and panchayats is people's participation. It's called the best school of democracy. Number 3, one of the objectives of local self-governance is to improve the efficiency of public service delivery by leveraging local knowledge and resources, thereby contributing to overall development and governance quality. Yes, that's also correct. How many statements are correct? Only 2 statements are correct. B is the right answer. Next. The 73rd Amendment Act of 1992, a landmark legislation in India, aimed to revitalize the Panchayati Raj system. Great. Consider the following statements regarding the Act. Okay. Number 1. The Act mandates the constitution of Gram Sabhas in all villages with a population of more than 500. No. There is no mandate of population. And otherwise as well, we have around 2.7 lakh Gram Panchayats, meaning for the respective Gram Sabhas, and we have around 6.7 or roughly 7 lakh villages in the country. So not every village will have a Gram Sabha. Sometimes Gram Sabha will be for a group of villages also. And the average population of every Gram Sabha is roughly 3.4 thousand, roughly. So an average Gram Sabha would comprise of 3 to 4,000 people. So small villages could combine to form one Gram Sabha. A big village could have a single Gram Sabha. So 1 is wrong. Number 2, the Act stipulates mandatory reservation of seats for backward classes. No. Mandatory reservation is for scheduled castes, scheduled tribes and women. But for the other backward classes, the OBCs, it's optional. The state legislature may by law provide for the reservation. Okay, so 2 is wrong. Number 3, it empowers panchayats with 29 subjects listed in the 10th schedule. No, not the 10th schedule, in the 11th schedule, because we know 10th schedule, what is that? Anti-defection law. So it empowers panchayats with 29 subjects listed in the 11th schedule of the constitution. This is also wrong. Subjects like agriculture, land improvement, family welfare, etc. So all 3 are wrong. How many or which of the above statements are incorrect? All of the above are incorrect. Okay. Next, with reference to the evolution of Panchayati Raj in India, consider the following statements. The first rural self-government was established in Madras in 1687. The first self-government was established in Madras. Of course, the Royal Charter of issued by King James II, which was issued in 1687 December, but came into effect in September 1688. So yes, this is correct. This is correct. This is wrong. It was not the rural self-government. It was the urban self-government. Municipalities. 1 is wrong. Number 2, the minimum age to contest in panchayat elections is 25 years. Of course, we know very well. For the Lok Sabha, 25 years. For the Assembly, 25 years. For Rajya Sabha, the upper house, 30 years. For the council, the upper house, 30 years. So for all the directly elected houses, the age is 25. So of course the same is the case with panchayats also. No. For panchayats, the minimum age to contest is 21 years, not 25 years. Okay. This is mentioned under Article 243 capital F article, not really important. This fact is important. So 2 is also wrong. Number 3, the state legislature by law can provide for the establishment of SFC. By law can provide. There is no can provide. It has to. It's a mandate. SFC is a mandatory provision. So it is mandatory. It is not an optional provision. This means what? This is also wrong. Okay. All 3 are wrong. How many statements are correct? None of the statements. D is the right answer. Next question. Consider the following statements regarding the reservation in panchayats and municipalities in India. The number of offices of chairpersons reserved for the scheduled castes and the scheduled tribes in the panchayats at each level should be in proportion to their population in the state. Yes. Reservation in panchayats, 243 capital D. Okay. Number 2, not less than 1/3 of the total number of seats amongst chairpersons in municipalities shall be reserved for women. See, this statement would have been correct for panchayats. In panchayats, 1/3 seats amongst chairpersons are reserved for women. That's correct. Not in the municipalities. So in the municipalities, amongst members, reservation for SCs, STs and women is the same based on population and based on 1/3 at least. But amongst chairpersons, there is no criteria set. In fact, the articles, there is the article 243, capital T if I'm not wrong, clause 4, which says that what is going to be the number of seats to be reserved for amongst chairpersons, that will be decided in such a manner as the state legislature may by law provide. So, state legislature will tell us what will be the reservation. Okay. So 2 is wrong. Which statement is correct? A. 1 only. Next question. The national emergency affects the financial relations in a way that it allows the union government to demand fiscal propriety of the state government. National emergency affects the financial relations in such a way that it allows the union government to demand the fiscal propriety, good behavior of state government. No, it's not the national emergency. It is the financial emergency. Article 360. This is wrong. It is financial emergency where the center will ask the states to follow canons of financial propriety. Rules of financially good behavior. Don't waste money. Number 2, the declaration of financial emergency changes the allocation of tax share between union and state government. No, this is the declaration of national emergency, which can change. The president can modify the what allocation or tax distribution among center and states. So I think it is just reversed. This was this, this was this. Okay, both statements are wrong. Which of the statements is correct? We know very well. D, neither 1 nor 2. Next question. With reference to financial emergency under Article 360, consider the following statements. Rajya Sabha has no role in approving or revoking a proclamation during financial emergency. Revoking, no control, but approving, yes, because financial emergency has to be approved by the parliament within 2 months. So 1 is actually wrong. Number 2, there is no maximum period prescribed for its operation. Yes, absolutely correct. Number 3, during its operation, the center acquires full control over the states in financial matters is also correct. 1 wrong, 2 and 3 right. Right answer is C, 2 and 3 only. Consider the following statements regarding the functions performed by the CAG, Comptroller and Auditor General of India. CAG Articles 148 to 151, right? CAG maintains the union government accounts and audits the same. Yes, of course, CAG audits the accounts of central government, but CAG does not maintain the accounts. Maintenance part has been given to the CGA, Controller General of Accounts, who heads the very important service, ICAS, Indian Civil Account Service, CGA. This body is under the Ministry of Finance, Department of Expenditure. And since 1976, it is this department, or it is this office that maintains the account of central government. CAG maintains the state government accounts and audits the same. Yes, this is correct. 1 is wrong, 2 is right. And mind you, the CAG does not audit local bodies. For local body audit, every state will have its own auditors that the state by law will decide. Okay, not the CAG. CAG might help, but will not directly audit. So 1 is right, 2 is wrong. Which of the statement is correct? B, 2 only. Next question. The office of SEC is what? This is the State Election Commissioner, which is a constitutional body, independent constitutional body, 243 capital K. An autonomous person like the Election Commissioner. An independent officer but linked to ECI. No, it's not linked to ECI. An officer under the indirect control of no indirect control. It's an independent constitutional body. A is the right answer, but let's read D as well. An officer who assists the functions of ECI. Nonsense. A is the right answer. Okay, next question. The electoral bond scheme, which was recently declared unconstitutional, allowed which of the following parties to receive electoral bonds? Political parties which were of course registered under the RPA 1951, section 29 capital A. If you are registered under this section, you can receive money through bonds. Apart from it, the political party should not have secured less than 1% votes in the last general election, either to the House of People or to the Legislative Assembly. 3 is correct, 1 is correct. 2, political parties with a minimum of 10 years of existence is wrong. This was not a criteria. So how many of the above are correct regarding criteria to receive electoral bonds? Only 2. B. Next. Consider the following: Arunachal, Mizoram, Nagaland, Manipur and Tripura. Which of the above mentioned states have tribal areas that are administered according to the 6th schedule? So basically states which have 6 schedule areas or tribal areas. Of course, we know 4 states: Mizoram, Tripura, Assam is not mentioned, Meghalaya is not mentioned. So others are not there. So 2 and 5, which are the states? 2 and 5, B. Next, Consider the following statements regarding MPC, Metropolitan Planning Committee. Mind you, MPC and DPC are both constitutional bodies. Please remember, and they are both framed under the same Amendment Act, that is at 74th. ZD is for DPC and for MPC it is 243 ZE. The state legislature may make provisions for the composition of MPC. This is actually correct. Not just this, in fact, the state legislature will also decide the manner of filling of the seats. Number 2, 3/4 of its members should be elected by the elected members of municipalities and chairpersons of the panchayats in the metropolitan area from amongst themselves. No, it's not 3/4. It is 2/3. Okay? 2/3, not 3/4. Number 3, the chairperson of such committees shall forward the developmental plan to the state government. Yes, of course, it is correct. Please refer to this article, clause 4. Exact sentence mentioned under clause 4. 1 and 3 are right. This would mean C is the right answer. 1 and 3 only. C. Okay. Next question. Which of the following explains the reason behind inclusion of emergency powers in the Indian Constitution? Emergency powers to safeguard federal character. When you have emergency, the entire constitution becomes so unitary in nature. How can we protect the federal features? This is wrong. To safeguard unity and integrity, yes, of course. To safeguard fundamental rights, I mean, during emergency, your rights can be suspended. So, of course not. To safeguard democratic political system, yes, of course. So, 2 and 4, B. Democratic political system, how? Because president's rule to ensure that the government of the state is being carried on in accordance with the provisions of the constitution. Next, the chairperson of a municipality is elected directly by the people or elected in the manner decided by the state legislature, elected in the manner that the governor decides, or elected by the members of the municipality. So, elected in a manner that the state legislature decides. This is Article 243 R, capital R, clause 2. I think subclause B, but this is not required. Just remember that the chairperson of the municipality, who is popularly known as mayor in most cities, or the chairperson of the Gram Panchayat, who is popularly called Sarpanch, Mukhya, President, Pradhan, etc. Both these people's elections is neither direct nor indirect, or can be both. How? State legislature to decide. That is why in some states the Mukhya, the Sarpanch, the Pradhan, the President is elected directly, and in other states indirectly. The same goes for mayors. So, elected in the manner decided by the state legislature. Okay, very important to note. Next, consider the following statements with respect to Schedule 5 areas. Schedule 5 areas are designated in states that have significant SC population to provide them with special protection and autonomy. Yes or no? Of course not. Scheduled areas are not meant for scheduled caste people. It is meant for scheduled tribes. Preponderance of ST population in a particular area. If more than 50% people are scheduled tribes, that area can be declared a scheduled area, not scheduled caste, scheduled tribes. Wrong. The legislature of the state containing Schedule 5 areas has the power to make regulations regarding the prohibition or restriction on the transfer of land from tribals to non-tribals. It's not the state legislature, it is the governor. Okay, so 2 is also wrong. Which of the above statements is or are correct? We know very well. Neither 1 nor 2. D. Next question. Which of the following statements about absentee voters is correct? Absentee voter, right? It was introduced in 2024 by the ECI to provide ease of voting to certain categories of citizens. No. It might have become popular recently, but this was introduced in 2019. and the RP was also modified accordingly. It includes senior citizens, people employed in the delivery of essential services. Yes, of course, absolutely correct. Migrant laborers and persons with disabilities. Now, this is correct. But migrant laborers and persons with disabilities, this point is correct, but not this point. Okay, so this was also wrong, this was also wrong. Now coming to C. Such voters are given a choice to either choose proxy or postal ballot. Mind you, whenever we talk about voting and the rights given to vote, we will always have the alternative of postal ballot, right? Either be physically present or choose postal ballot. Proxy voting is only for one type of voter, and that is a service voter. Okay, nobody else. C is also wrong. None of the above. D is the right answer. Okay. Next question. Consider the following statements regarding official languages under Schedule 8 of the Constitution. Official languages. It comprised of 22 languages at the commencement of the Constitution. 22 or how many? 14, not 22. Any modification in the 8th schedule can only be done by Parliament by law. No. If you want to modify the 8th schedule or languages, then you need to use Article 368, a special majority constitutional amendment. For example, 96th Amendment Act was used in 2011 to change the spelling of one of the official languages. Please write in the comment section which spelling or which language's spelling was modified from the 8th schedule through this Amendment Act. Let's see. Number 3. In 1992, English was added to the 8th schedule. Of course, wrong. Don't take it seriously. This is a wrong statement. English is not a part of 8th schedule. Hindi is there. Sanskrit is there. Of course, we have the other languages. Though in 1992, there was the 71st Amendment Act, which did add 3 languages. Those 3 were, one was Konkani and then Nepali, Manipuri. Yes. So Nepali, Manipuri and Konkani. These 3 languages were added in 1992 by the 71st Amendment Act. Next question. Consider the following statements regarding RTI, Right to Information Act. It allows both citizens and aliens the right to information. Citizens and aliens, no. This act is applicable or available to all citizens. That's what the law says, not to aliens. Number 2, Section 8 of the Act provides for exemptions which relate to strategic interest affecting the interests of the country. Yes, there are certain pieces of information or certain requests or certain questions that you cannot ask. Why? Because it might jeopardize the interest of the country, or there are other provisions which are mentioned under Section 8 of this RTI Act 2005. Number 3, as per the Act, every public authority must provide information within 7 days in case the information relates to life and liberty. No. See, information must be provided in 30 days. And if the information relates to life or liberty, then within 2 days, 48 hours only, not 7 days. So 3 is wrong. 1 is wrong, 3 is wrong, 2 is right. How many statements are correct? A. Only 1. Next question. Consider the following statements about the Comptroller and Auditor General of India. The CAG must subscribe to an oath mentioned in the 2nd schedule. CAG must subscribe to an oath mentioned in the 2nd schedule. See, Article 148, Clause 2 talks about this oath, but the oath we know is mentioned in the 3rd schedule. 2nd schedule contains what? Salaries and emoluments. 1 is wrong. Number 2, he is appointed by the President and can only be removed from office in the same manner and on the same grounds as Judge of Supreme Court. Yes or no? Yes. Article 148, Clause 1. Appointment is a bit, shady because the center appoints the CAG, but removal is independent. Who is the current CAG? Please tell me. A former Gujarat cadre IAS officer is the current CAG. Please write in the comment section who is the current CAG of our country. Number 3, after leaving office, the CAG is not eligible for any other government office, whether under the Government of India or any state government. Yes, this is to prevent any kind of favor towards the government, because once you leave the office, you are not eligible for any benefits from the government. How many of the above statements are correct? B. Only 2 statements are correct. Next question. Which of the following provisions related to the Panchayati Raj system is or are correct under the Indian Constitution after the 73rd Amendment? The state legislature shall endow the panchayats. Shall. It's not shall. It's an optional provision. May. May endow, meaning provide, the panchayats with the powers and authority to function as institutions of self-government. This is Article 243, capital G. This is wrong. Number 2, the duration of panchayats at each level is fixed at 5 years from the date of their first meeting, and elections must be held before the expiry of this period. Yes, of course, it's correct. All the seats in the panchayat are filled by direct election from the territorial constituencies in the panchayat area. Is correct. And the chairperson of a panchayat at a village level shall be elected directly by the people. I just explained this is wrong. Why? The chairperson of a panchayat at the village level shall be elected in a manner that the state legislature by law decides. Now the point is, what about the chairpersons of other levels like the intermediate level or the district level? Here the election is indirect. Okay, at these levels the constitution says that the election is indirect, whereas for the chairperson of the Gram Panchayat, state legislature decides. It can be direct or indirect. So 4 is wrong. 2 and 3 are correct. We have to choose the correct statement. B is the right answer. Next question. Consider the following functional items: public amenities, regulation of slaughterhouses and tanneries, roads and bridges, women and child development, fire services. How many of the above are not a part of 12th schedule of the Indian Constitution? 12th schedule contains a list of 18 functional items on which the municipalities may be allowed to make laws if the state provides. Let's see. Public amenities, yes, of course. There are a lot of things in the 12th schedule, urban planning, town planning, planning of land, land use, construction of these buildings, planning of for economic and social development, roads and bridges. We have roads and bridges, public amenities, regulation of slaughterhouses, fire services, water supply for domestic use, industrial use, commercial purposes, public health, sanitation, all such things. Urban forestry is also there. Safeguarding the interest of weaker sections is mentioned, including handicapped and mentally retarded, right? Slum improvement. Though this phrase women and child development is not mentioned under 12th schedule categorically, this phrase is actually mentioned under 11th schedule. Under the 12th schedule, they have a phrase called safeguarding the interest of weaker sections of society, including the handicapped and the mentally retarded. That phrase is used. This is under 11th schedule, so not a part of 12th schedule. Fire services, yes, of course. So 1, 2, 3 and 5. Okay, how many? So we know how many. How many are not a part? Only one is not a part, which is women and child development, which is a part of 11th schedule, which contains a list of 29 topics on which panchayats can be allowed to make laws. Okay. And finally, the last question for today and the last question for our polity session. With reference to the MCC, the Model Code of Conduct in Elections, consider the following statements. It becomes effective from the date of announcement of the election schedule and remains in effect until the election results are declared. Yes, absolutely correct. MCC comes into force on that very date the Election Commission of India announces the schedule. Okay. Number 2, it stipulates that ministers must not combine official visits with election campaigning at any time. Absolutely correct. See, the MCC explicitly mandates that ministers must not combine official visits with election activities or utilize machinery, this official machinery, for campaigning. Additionally, the ruling party is also prohibited from using government transport, government machinery, etc. for campaigning purposes. And it also requires that the public venues, maidans, right, etc. for holding elections, election meetings, and facilities like helipads, they should be made available to opposition parties under the same terms and conditions as they are made to the party in power. So yes, 2 is correct. The idea of fairness in the elections, equal opportunity. And number 3, it considers unfulfilled promises made in election manifestos by candidates as a form of corrupt practice. We wish this was the case. Political parties and candidates are not required to disclose any financial implications of the promises made in their election manifestos. According to Part 8 of this guidelines on the election manifestos, promises made in these elections, they are not deemed to be corrupt practices, sadly. So 3 is wrong. My question to you, how many of you feel that the party, any party which has any kind of election manifesto, poll promise, should justify from where are they going to get the funds for its freebies? Of course, some kind of freebies are required if it benefits the weaker section. But what will be the possible financial implication? Do you think that it is appropriate that the party also mentions in its manifesto that this is the freebie that we are going to provide, free money, free this, free that, and this is the financial implication, and this is the step we are going to take to ensure that we get funds? If you agree, please mention, or else you say no, not required, we can keep on giving freebies, no need to mention anything, time will decide, no problem. You can write accordingly in the comment section. Okay, so how many statements are incorrect? A, only one statement is incorrect. That's it for our questions on polity. The purpose of these questions and these sessions is not to second guess the examination questions, but to let you be aware of what are the possible types of questions that can be asked, number 1. Number 2, to tell you also which topics were important in the recent times. So normally in the prelims, the focus is always on static portion, right? So current affairs will help us know which static topic is more important. So you can do selective revision of those topics, right? That's the whole point. We have the schedule at the beginning of this video and the last 4 videos. You can see the schedule, go through it. In the PPT as well, the schedule has been mentioned. Please go to the schedule and attend the classes accordingly. It will be of great help to you. And yes, time is running short. Please make sure you put in the best possible effort, right? Rather than putting in half-hearted effort every, a year, put in all your effort and sail through the examination, because this exam is going to change your life completely. Okay, that's it for me, guys, for this video and the polity sessions. We'll meet the next time. Till then, that is going to be all for me. Jai Hind.